whole reason that you're here, the gentleman that's in the back, we've got Davidson Law Group, and we've got Brian Campbell that's here to be able to talk about estate planning to go. And so nobody's here to see me, so I'm going to get out of the way. Thank y'all very much. Y'all have a good one.
Thank you. We also have James Davidson. His name's on the firm, so he's important. Make sure we recognize him. So James is here as well. And we really want this to be a conversation. We were just talking to Charlie in the back and said, nobody likes to be talked to. And so if you have any questions as we go along talking about estate planning, please feel free to interject. We're happy to answer any questions, maybe some real life scenarios that you've experienced, how we might handle those. And so please feel free. We don't have to wait till the end. If you've got a question popping into your head, just signal us and we'll be sure to call on you and address your questions. All right.
And thank you, Brian. And so obviously we're attorneys and we're estate attorneys. And so why are we here? What are we here to talk about? We're all in a service-based industry. We provide a service to clients. We're all licensed, and so for all of us, the name of the game is how do we add value to our clients, right? And how do we differentiate ourselves from other capable professionals? And I think really a partnership in some form or fashion between an attorney, broker, agent, whatever the case may be. If you really look at it granularly, there's a lot of symbiotic value that we can give to one another as attorney, agent, broker, whatever that looks like. And especially as estate attorneys, because what Brian and I do primarily is help people plan for the transition of control and assets in the event of death or incapacity. And primarily death is what we're here to talk about, unfortunately. But I'm sure we've all been involved with closings where you get right up to the very end and they run title and all of a sudden there's an issue. Husband and wife owned the house, husband passed away, and they never did anything to cure title, to get everything solely into wife's name so that they can have good and marketable title and close. And so it's always a scramble to figure out, are we doing affidavit of heirship or do we have to probate? And so we've all been in those situations. And when you can issue spot, get ahead of things like that, and really add value to your clients by working with folks like us to do just that, to get ahead of the issue, to point out the value that you're adding to your client, and to have a smooth closing. That's what we all want, right? And so we're here to talk about some things that you can really look for in terms of issue spotting as the agent broker to do just that, to identify the issue, get ahead of it, and to add value to the client.
Sure. So I think our first slide here is what is an estate and what is an estate plan. And I think James probably has experienced this as well. Most people that we see probably think, I don't have an estate. I don't need an estate plan. I don't need a will. I don't need powers of attorney because I don't have anything. And the fact of the matter is everybody has an estate. And whether that's your home, whether that's, I know we don't consider children as part of our estate, but children are an important part of an estate plan if they're minors. And so we want to make sure that those are covered. So we've got personal effects. Everybody has personal effects. Those are things like your household items, your vehicles, your boats, your ATVs, your fun toys. And so, everybody also has some kind of financial assets, whether that's bank account, money market, investment accounts, stocks and bonds. A lot of people moving into cryptocurrency, and so they'll have some digital assets. But most people that you come in contact with as realtors are going to have some kind of financial assets. And then, of course, where you come in, real estate. Not everybody owns a home, but a lot of us do own homes, and so it's important to consider that in your estate.
It's up to us everybody will own a home.
That's right. That's right.
That's what we do,
That's
right?
right. They'll all use Keller Williams.
Yes, yes.
Right. And then of course you have things like medical affairs. And so, an estate plan covers more than just, a will, but it also includes things like, what happens if mom and dad or spouse becomes incapacitated? Then what are they gonna do? Who can make medical decisions on that? And so, a lot of times people think of an estate plan as just a will or a trust, but there's so much more that goes into it than just those documents. Is that kind of your experience? Most people feeling like, oh, I don't have anything.
Yeah, absolutely. And they say the same thing about estate plans as well. I don't have an estate plan and I don't need one because I don't have an estate. Well, the fact of the matter is, as Brian alluded to, yes, you do. And you have an estate plan, whether you realize it or not, because the state of Texas wrote one for you. And chances are it's not reflective of what your true wishes are. And if it comes time to utilize the state, issued estate plan, well, it's going to be a lot more problematic, a lot more difficult. And, we all know that those two words mean more expensive in the long run. So again, by getting ahead of it, you can solve a lot of problems before they become problems.
I like the way you put that. That the state of Texas has one for you. So a lot of people don't know.
And that's what I ask clients is the state of Texas has written one for you. Do you know what it says? No. Do you know how it applies to your set of facts? No. Wouldn't you rather write your own and take control of that and know what the outcome is going to be ahead of time? And the answer is obviously yes.
Especially when there's one family.
Yeah, 100%.
So that segues nicely into this next slide. The question is, who's going to create your estate plan? Going to be you, or is it going to be the state? Because like James said, the state has a plan for you, and most people don't like that, especially if you have a blended family, or as I've seen a lot more recently, if you have a member of the family that's kind of estranged, that's on the outs, that you don't want to include them for one reason or another. Maybe they have some addiction problems, or you haven't seen them in 20 years.
Or special needs.
Or special needs, or you don't want them to inherit something because inheriting something may disqualify them from getting government benefits that they currently receive. And so it's very important that we have these conversations with our clients, because if you don't draft one yourself, like James says, the state has one for you, and more often than not, the clients aren't real excited about the plan that the state has for you. So we go into probate court, family court, the state of Texas, which has a plan if you have no will. The bottom line is the best person to draft your estate plan is you. Your set of circumstances better than the state of Texas. Your set of circumstances better than a probate court or family court. And so it's important that you kind of steer the ship in the way in which that you want that estate plan to be done.
Yeah, and a lot of times we're so focused on the assets or the monetary side of that, which is obviously important, but only you can determine outside of the money side of things what values, what family stories, what cultural cultural things do we want to convey to our children or to our beneficiaries alongside the asset, and really shove the continuity into place as to the stewardship, right? The stewardship around how those assets are treated, how money is spent, what values do we want to tie to that money? And so like for me, I'm a Christian, and my wife and I, it's very important to us for our children that we teach them how to steward assets, how to take care of real property, and how to transition ownership from one generation to another. So it's not all about money. It's about the values that you want to tie to that and convey also along with the assets.
And the medical directive is something I had never even thought of when I first went to the Davidson law firm. Although my daughter, Caleb, I don't know if y'all know that's my daughter. She just got a real estate license. She is also an independent client of theirs as well. So she's created a trust with them. I created one for the whole family, the two of us. But the medical directive, I hadn't even thought of that. Power of attorney, sure, while I'm still breathing. But what happens after I'm not breathing? Well, there's no more POA. There's no more power of attorney. And I didn't want her to bleed all my sweat and effort into creating the money that this trust has in it by keeping me alive if I'm still breathing air. So I took it away from her. They set it up for me that there's a medical directive that if they haven't figured it out in a week, what's wrong with me, let me know. And she's furious about that. But I know she loves me so much, she would keep me alive forever and drain all the work and all the finances and all the assets that I put together my entire life. And my, previous generations too had worked so hard to create all of that, which it is hers. But I wanted to make sure through a medical directive that it continues to be hers and her children and further on down. So that was surprising when I sat with you an entire afternoon to be presented with that kind of question. I hadn't even thought of that. So I just wanted to interject and say thank you for bringing up all those type of questions I had never even thought of before. And now it's in place.
Yeah.
So she doesn't.
Very good. Very.
But thank you. Thank you.
Yeah.
Changed our life.
Yeah, and that is an excellent point, in that having the conversation identifies things that you hadn't even thought about, right? And then it gives you an opportunity with, no pressure to have, an educated conversation with someone like Brian and I to really gather all the information you need to make an informed decision for you and your family. And if you're married and you have a spouse, to talk about, the planning and identifying the issues and really coming to a thoughtful, prayerful decision as to things like end of life and under what circumstances would I want treatment to be discontinued and simply to be made comfortable, or under what circumstances do the assets transition and how do they transition? What are the tax implications and all of those dominoes that trip once you trip the first domino? So that's a great point, Charlie.
Which leads us to our next slide. What happens to me or my loved ones if we become incapacitated? And so I'm going to switch with you.
Yeah.
It's closer over here. So there's a couple options. So and these are some of the things that Charlie talked about, but first and foremost, is a trust. And so, James, why don't you explain how a trust helps when there's incapacity or if a loved one becomes disabled?
Yeah, absolutely. And so let's start with the basics of what is a trust. And trust is simply an agreement between three parties. And those three parties are, one, what's called the grantor or settlor, which is a common synonym, which is a term that indicates the creator of the trust, who created it and whose assets are in it. Okay. And a lot of times when we're talking about revocable trusts, it's who's the taxpayer. And so that's going to be, the creator of the trust for a grantor trust. The second party is the trustee. So who manages it? Who manages the stuff, makes decisions, regarding the beneficiaries and the assets in the trust. And then third is the beneficiary. So who has the right to benefit from the trust? And that, can look a lot of different ways. It can be a lifetime beneficiary, a death beneficiary, a contingent beneficiary, whatever the case may be. But ultimately, that term indicates who gets to benefit from the stuff in the trust. And so collectively, all three parties, you create the trust, you manage the trust, it's your stuff in the trust, and you benefit from the trust. So in large part, the vast majority of the types of trusts out there, a good portion of them are revocable living trusts or family trusts. And if it is a family trust or a revocable trust, you are all three parties. Or if you're married, you and your spouse are all three parties. You're the creator, you're the manager, and you're benefiting from the stuff in the trust. And so when it comes to incapacity, again, the state of Texas has written a plan for you. Within that plan is incapacity. So the state has defined when and if you become incapacitated, and it's going to be up to your attending physician or a judge to determine if you are incapacitated. Well, a lot of times, and people don't realize that if there's a formal judicial or a formal medical determination of incapacity, where you get stripped of certain constitutional rights. You no longer get to vote. You can't serve in a fiduciary capacity, meaning you can't be a licensed agent or broker. You can't own a firearm. There's a lot of things that happen that you really don't anticipate a lot of times. And so it's a situation that if you can avoid it, then absolutely let's avoid it. And again, you avoid it by writing your own plan. And within your trust, at least the way that we draft them is we spend a whole article within your trust defining incapacity. What does that mean? And what mechanism do we use to determine if I am, right? And again, that's going to be up to you. So it might look like, my spouse and my oldest child and attending physician will collectively make that decision. It's going to be a majority rules, or hey, it's got to be unanimous. Or, if you're and we're in East Texas, so there's a lot of folks like this that, you don't trust doctors. So they don't want a physician involved in that decision, and that's okay. I can understand that. And so they might put, some family members or a pastor or whatever, but you get to determine what the definition of incapacity is and who determines if you meet that definition. And so once that's triggered within a trust, the incapacity trustee steps in and manages the trust and can do things like pay bills, buy and sell real estate, whatever the case may be. You're vested with authority under the trust to then act on behalf of the trust and the beneficiaries within the trust.
And you get to a point who that successor backup trustee is in the event you become incapacitated. And you can name one person. I've had people name multiple people. You can have them serve individually. You can have them serve collectively. And so you need to determine all of that while you have capacity so that in the event you do lose capacity, that's already set up for you. The document's already there. You don't have to go to court. You don't have to deal with guardianship. It's all there in the document. And then there's other forms as well that are important. And you'll see those on the screen. The first is a durable power of attorney. That covers basically your financial assets. And so in the event you become incapacitated, who's going to manage the bank account? Who's going to manage paying the bills? Who's going to manage buying and selling real estate? Who's going to be able to contact Edward Jones and buy and sell and trade stocks? And so that statutory durable power of attorney is the document that states who has the authority to do all of that. And of course, if you have a trust, it's governed by the trust, but a lot of people will just do a will and they'll just do standalone durable powers of attorney.
Mm-hmm. And a lot of times in closing situations, you might have a family trust that owns the property, and the property was purchased. There's a mortgage on it, and then it was subsequently conveyed into the trust. So the trust owns it, but the mortgage is still in the individual's name. So you might come to a closing and you're acting in multiple capacities as the trustee of the trust or as attorney in fact under the power of attorney, dealing with the mortgage company and getting the payoff amount and all of that stuff. So so a lot of times you're wearing multiple hats. And you guys have probably seen this before, but not all powers of attorney are created equal. And so you get to a closing and there might be a defect on the power of attorney, or it might be missing a power that you need. And the underwriter comes back and says, hey, yeah, we don't have this. And so, we can't close. You're either going to have to get a new power of attorney or get a guardianship. And then we're talking guardianship, then we're talking weeks to months before anything happens. And so by again, issue spotting and getting ahead of these things, you can provide a lot of value to the client.
Yeah. I had a durable power of attorney recently that conveyed no power.
Yeah.
And so, they did it on LegalZoom, and they didn't know how to fill the form out. And when they went to closing, the underwriter said, well, this power of attorney does absolutely nothing, doesn't convey any powers. And so then we're stuck. Then we have to go through a guardianship route. So then we've got a medical power of attorney. Medical power of attorney is the document that states who can make medical decisions on your behalf if you can't make them on your own. Really important that the state has an order in which people can make those decisions if you don't have one, but a lot of times clients don't want particular people in their family making those medical decisions. I see clients all the time. Well, I don't want my daughter making medical decisions because, she's got a bleeding heart and she'll keep me on life support as long as possible, but I don't, yeah, exactly. But I don't want my son because my son will pull the plug as soon as the doctor says I'm incapacitated. So what do I do? So again, these are all things that you need to take care of in advance, because if you don't take care of them, then the state does still have a plan for you. And then
No, I said, yep, you're right on.
and then finally, appointment of guardians. Now, this is kind of a last resort in my opinion. Well, it's always important to appoint who you want to serve as a guardian, should you need one. And so, we've got a document called Declaration of Guardian, where you get to say, Judge, I've got capacity today, and while I have capacity, I want James to serve as my legal guardian should I ever need one. That just keeps family members from fighting them. And typically I see family members fighting over people when mom and dad have a lot of wealth. And so all the kids want to be the guardian at that point when there's a lot of wealth. And so this document states to the judge, Judge, this is who I want to serve as my guardian, and then these are the backups to that guardian in succession, so that the court doesn't have to guess as to who the best person to be your guardian would be. But a guardianship process can be very lengthy, can be very long. There are temporary emergency guardianships that are shortened, but for the most part, most people don't really qualify for that. They need to go through a full-blown guardianship, and that can take 6 months. And it can be very expensive. And it can put the family through a lot of grief and angst. And so while you have capacity, it's important to go ahead and plan for these things so that your family doesn't have to be scrambling at the last minute or at the closing table when they're trying to sell mom's house to take care of her in memory care. The last thing they want to have to do is pause things for 6 months and go through an extended court process.
Yep.
And the trust and the will, to touch base with that, I'm sure y'all are gonna probably do that next, but what I've seen, and I'm sure y'all have too, is people, oh, don't worry about it, I have a will. I'm like, oh, no, what does it say? Who did it leave out? But the common thing I hear, they have a will, is they're like, yeah, I have a power of attorney, so when my dad dies, I can take over, and we've already discussed I'm gonna sell the house and blah, blah, blah. I'm like, okay, here's y'all's telephone number, because I'm not an attorney, we're not attorneys, I don't think any of us are. But as their realtor, I say, okay, there might be a question about when your dad passes away. Something about maybe you don't have power of attorney from that point on. It's only when he's living, but I don't know. Just, wanted to show that out there. Here's y'all's business card. Please call them, because I don't really think that's how it works. But, ask the attorneys about it. And also in that same situation, he lived in the Netherlands, this gentleman, the son, and deactivated explosives in the Duncan in Africa. Wow. So he had a power of attorney though when his dad died, and he was my neighbor, actually, the gentleman that passed away. And so he thought he had power of attorney, and he didn't. It also didn't mention the other 2 kids, and one was in prison and estranged. For at least, I think it was 32 years or 35 years, something like that. And so now the will had to be probated. Well, then the son had to go back to Africa, and then he put me as the power of attorney, and I accepted only because I wanted the experience of absolute living hell. It was terrible to be a part of that. And about that later, I was back to Africa. I'm the power of attorney, and I took care of everything, and it was extremely hard to sit there and watch this gentleman have to go through his dad's death, thinking he had power of attorney. He can't do anything. They had airplanes, they had boats, they had houses, they had investments, they had a cell phone that I couldn't figure out the code to get in to cancel it. But I mean, it was a whole ball of horrible wax. And it was amazing now to know when I speak to my clients at closing, one of their largest assets of their entire life is you have a will. here's James' telephone number. Think about having a trust. Make sure the will is actually written in your family's best interest. No, it don't have to be probated, but consider a trust, because a trust never dies. And so having brought up those little topics, y'all might have had the same.
Well, I know one of the first things that people are gonna ask when I do this, is, well, how much is this gonna cost me?
Mhm.
So ballpark, how much is it gonna cost? I mean, I know it varies.
Yeah.
Because of how much of what, but an idea.
Yeah, and like you said, it really just depends on the scope of work and you know, what we're doing within that scope of work. But my response when clients ask that is whatever number it is, it's gonna be a lot less than what it would be without it. But, you know, just to give you an example, like a single will plan, which would be a will, all the powers of attorney, ancillary documents, you know, somewhere around 1,500, 2,000. You know, joint will plan, somewhere between 2 and 3, trust, depending on how complicated the funding is, anywhere between 3,500 and sky's the limit. So somewhere around that, but clients obviously typically are cost averse, but they're willing to spend money on things that they see value on. So that's where the salesmanship comes into play, not in painting it in a light where you know, I can charge as much as possible, but it's just communicating the value add. And so I always tell the story, speaking of LegalZoom, one of the first, so I've been doing this for 15 years. Brian, you were licensed when?
2001.
2001.
26 years.
26 years. One of the first cases that I worked on right out of law school was it was a LegalZoom divorce. As husband and wife, they were from Texas. They were both college professors at Washington State University, and they got married, had a baby, and they decided they were going to get divorced and move back to Texas. And you know, they were college professors, so they were smart and they could figure this out themselves. And so while they were in the state of Washington, they filed in Texas. They did a LegalZoom divorce in child custody, presented to a judge, and got, you know, signed off on it. And I want to say it cost them $360, something like that. Well, what they didn't understand is that they lied on their application. They lied on the face of all the pleadings, and stating that they lived in Texas. And so when we got retained to defend the husband in this child custody modification in Fredericksburg, Texas, Gillespie County, first thing I noticed that there was no standing, there was no jurisdiction. So we got the entire divorce decree tossed out, including everything in it. And what, you know, cost them $360 in the first place ended up costing combined over $600,000 in attorney's fees. And if they had just done it right the first time, it might have cost them 10 grand, okay? Which is a lot of money, but it's an investment in an outcome. And you want that outcome to be favorable. And when that outcome's not favorable, that's when it gets expensive. So, so to answer your question directly, it's somewhere in that range, okay? And something we'll talk about here in a moment. Anytime we are doing will plans and they also own real estate, then we'll incorporate ladybird deeds or transfer on debt deeds. And that's a very, very powerful tool and relatively inexpensive, that does a lot of different things. And so our fee for deed combined with you know, will plan, it's going to be around $500, depending on how many deeds we're doing.
Do y'all go to court during the probate so you get hired again and have some more fees if it's a will? I'm just curious.
Yeah, and no, that is a tactic that a lot of attorneys use.
I've had someone in Linville do that.
The loss leader.
They did a will for this family and then they had the real estate in a trust under the will and told her she wouldn't have to probate for me to sell the house. Lie. I mean, just write out, okay, non-truths. Is that what we call it?
And they created 3 additional unnecessary steps.
Yeah.
That are going to be more attorney's fees to the attorney. Yeah.
I think the way we operate is we try to keep our clients out of court.
Yeah.
Yes.
100%.
We try to set up the solution to the problem that keeps everybody out of court, because it's, you know, court is costly, it's time consuming, especially if you've got a deadline like a closing. And so
It's unpredictable.
it's unpredictable. You don't know who's gonna show up and contest anything. And so our whole approach is let's keep the client out of the courthouse, so that we don't have all those issues. I just think that's the right thing to do for the client.
Yeah, and if the attorney is ethical, and we are ethical attorneys, and going back to something that Charlie said to me back there is, I generally don't trust attorneys, and that's true, and I don't either. But the thing is anytime you add a human element to anything, you have opportunity for shysters, right? And so I would correct my statement by saying I generally don't trust people. Okay. But when you find somebody that you can trust, that you have experience with, and the fact that we're here is because we have imputed trust with Charlie. And so when you find that attorney, that partnership, it can be so valuable. And like Charlie and I are on texting terms. I'll text her if I need something. She'll text me if she needs something or has a question. And of course, I don't charge her for any of that. It's a symbiotic relationship because I trust her and she trusts me. In fact, there was last year, I got asked to be a trustee of this trust, and she can tell you all about the beneficiaries that are involved. Again, just not trusting people, and people suck. These people fit right into that. But Charlie stepped in, and I told her from the beginning, this is really going to suck, but I trust you and I appreciate it. And she came in, and as the trustee, I was selling the house. It was a house in
Teasville.
What's the neighborhood? I forget. It's on Lake Palestine.
What's that neighborhood?
I'll think of it in a minute. My parents used to own a house in there.
Eaglesville?
No, it's the other major one.
Yeah, Cumberland Estates.
Cumberland Ridge.
Cumberland
Ridge.
Woo.
So it was a house in Cumberland Ridge, but it was the crappiest house in Cumberland Ridge. But Charlie came in, and the house was full of stuff. It was dirty. It was nasty. And she hired the people to clean it up. She did an estate sale, and she oversaw the roofers putting a roof on it.
Which they had actually paid, the kids got the money for it,
Yeah.
right? They got paid out by insurance, which is illegal, but then I was like, it needs a new roof or I'm not gonna list it.
Yeah.
And so he took care of that for me. I was
Yeah.
like, oh God, thank God.
Yeah.
Yeah, and then oversaw a new roof and then, go ahead, I'm so sorry.
No,
That was like a
yeah.
little caveat that I'm sure y'all have experienced.
Yeah.
In Texas, where the insurance companies will pay the rat for the roof, and then the family took the money and they never replaced the roof. That's happening to me multiple times. I'm going through that. You're going through that right now.
And on seller's disclosure, they didn't disclose that. So I mean, that's a misdemeanor right there. But the point of me saying this is that when you find, and hopefully we can be those people for you, but it doesn't have to be. But you need to find that trusted relationship where you are on texting terms and you can bounce questions off and be, as the agent broker, be available, to jump on it at the drop of a hat, like Charlie did. But when you have that trust and you can give that imputed trust to the client, come talk to the attorney that you have a relationship with, then it's always going to yield a better outcome, even if there is a fee involved, which there always is. And I'm sure you guys experience this. Nobody works for free until they hire an attorney and expect the attorney to work for free. And I'm sure you guys get that too. 3%, that's ridiculous. But what they don't see is all the labor in the background. Like Charlie, you earned every bit of your whatever it was, 6-7%. But huge value add.
To kind of piggyback on that, and your question, it's always, at least in my experience, it's always less expensive to deal with your inmates. And so if you're looking at the cost of probate with the will, I think the average cost in Texas is probably somewhere around $4 to $5 grand.
And that's with attorney's fees and court fees.
Court fees and all that. And then if you pass away in Texas without a will, it gets exponentially more expensive. So you're looking at probably around $8 to $10 grand if you don't have a will. And so, yes, and there is a little bit of cost up front, but you're saving your family a lot of cost on the back end, not to mention the not having to deal with the grief of having to, I've just lost a parent and now I have to go see an attorney to probate the will and the court. And that's just something I didn't want to do or plan on doing. And we can help alleviate all that by keeping the family out of court. But I also wanted to mention something Charlie had talked about with powers of attorney. A lot of people don't realize that powers of attorney die with you. And so I always get people coming in and saying, well, I don't need to be appointed the executor because I have the power of attorney. And I said, that power of attorney expired when mom or dad or spouse passed. And so that document is basically null and void at this point, and certainly isn't the same as, you being appointed an executor by court. Any other questions before we move on? Maybe we'll get other questions. Right. What happens to my assets upon my passing? Okay. A lot of different options here. The first one is with the trust. Trust is by far, in my opinion, the easiest.
And preferred, yeah.
And preferred. Again, it keeps people out of court, generally. You don't see people go into court when they have trust, not the probate. And so, a trust basically, people always say, well, you can't control things from beyond the grave. And I say, well, you can if you have a trust. And so that's not entirely true. And so, and a lot of times I tell people, if you can dream it up, we can draft it up. And so a trust can kind of control things from beyond the grave. And I've got clients that say, I want to leave my estate equally to my 3 kids, but I don't want them to get it all at one time. I want them to get a percentage each year for 10 years or for 20 years or for however long. Sometimes I never want them to be able to touch it. I want them to always have to go to somebody else, so there's checks and balances. I've had a couple W-2 matchings. I don't know if you ever had any of those, where I don't want my kids to get these millions of dollars and then just quit work. Right. And so, I've had some clients say, I want to put a provision in there that they have to take a trustee, my trustee, their W-2 every year, and my trustee will match it. And so, if they've got a job earning $100,000 a year, now they get $200,000 a year. But they're going to want to keep trying to strive to do better because, they're going to get a matching amount at the end of the year. And of course, we make provisions in there for if it's a stay-at-home mom or if somebody, if the child becomes incapacitated. But those are just some things that I've seen. But passing the assets through a trust is, in my opinion, the easiest and quickest for people.
No, 100%. And if the trust is drafted properly and it's funded, meaning that the assets are titled in the name of the trust, and so many times we have a client come in for a consult and say, yeah, mom passed, but she's got a trust, so it's going to be easy. I'm like, great, what's in it? Well, everything. Okay, show me. Well, I don't have anything. And well, let's look it up. Let's look the deed up. Well, okay, the appraisal district says that it's still in mom's name. Was there a deed drafted? Well, I don't know. Well, looks like there's nothing in here. Okay. And so in that instance, you have a very expensive paperweight. Okay. And oftentimes there's a corresponding pour over will, and now we're having to probate the pour over will to get everything in the trust to then administer the trust. And so by not following through, and really it's on the attorney, in my opinion, to stay on top of it. But again, we can only do so much. And you guys, I'm sure, see this all the time where you insist that your clients do things or whatever, and they just, for whatever reason, just never do it. But of course, it's your duty to try, and so that's what we do. But an unfunded trust inevitably is going to create a probate. But with wills, and unless it is done properly with all the other probate avoidance tools surrounding it, you're going to have to probate the will. And like Charlie said earlier, a lot of attorneys to generate new business will, which is very unethical in my opinion, will insist on a will and will tell the client things like, oh, you don't need a trust, trusts are stupid, or you don't have enough money for a trust. And that is just patently false. Okay. I'm kind of going on a tangent here, but trusts and money has nothing to do with it. Okay. It's all about your objectives. And if your objectives are things like probate avoidance, remarriage protection, special needs children or incentive-based distributions to your kids, where you're not just dropping a sack of cash in their lap and saying, good luck. And so if that is what you value and what you want to achieve, then a trust all day long is going to do that. And what she said earlier about creating trust through wills, and yes, there's a time and a place for that. But by doing that, you're creating additional steps. And by creating additional steps, you're creating opportunities to build. And that is very unethical. But with a will, so if you have a will and no other probate avoidance tools, and you pass away, of course, we're going to have to probate. Okay. And, I don't want to beat a dead horse, but probate, it's not the end of the world, especially in the state of Texas. We're not the worst probate state, but there's opportunity for a lot of things to go wrong. And it is a very easy thing to avoid if done properly. But in my opinion, it's an unnecessary expense of time, money, and effort at a time where you least want to expend that. Okay, but let's talk about what a probate looks like. And I'm sure you've all seen that. But, I have a will, client comes in, spouse passed away, and it becomes evident that we need to probate the will. So we file the application to probate the will in the appropriate court. In Smith County, it's going to be with the county judge, in the probate court. And we file the application, we wait all the statutory deadlines, we set a hearing, we go to the hearing, we do an easy prove up, 10, 15 minutes, we're out of there. And then we have letters testamentary, and those letters testamentary and the order are the keys that unlock the kingdom. And so if we've got a pending closing, well then, we've got those letters testamentary, we record those in the real property records, along with all the other probate documents, and we're teed up and we're ready to go. Okay. And so if the attorney knows what they're doing in filing the application and what needs to be in the order, then it should be pretty simple. Okay. But again, there's a lot of opportunities for things to go wrong. For example, like, I don't know if you've all seen this, but are you familiar with the power of sale? Have you ever heard that term? Okay. And so if you have a probate and you're selling real estate, if you don't want to have to drag all the beneficiaries into the closing and have them sign off, well, your order has to give power of sale, whether the will says it or not. And that's the first thing that the underwriters are going to look at. So there's things like that need to be in the order that if the attorney doesn't know what they're doing are going to cause a ton of problems, and it's going to, sort of frustrate the entire purpose of what you're doing to begin with. So that just goes to show why it's important that you have somebody who knows what they're doing. But with a will, you can pretty much count on 3 to 6 months from date of death to hearing before you can really start doing things. And if you've got real property that needs to be managed or sold, that just creates a lot of problems. And oftentimes it's every month that goes by, it's mortgage payments, it's property taxes, it's insurance, and money might be tight. So it's really important that you act speedily and get things managed. But again, not the end of the world, but oftentimes does not lead to a desirable result.
And power of the sale, y'all have heard, this is my introducing teaching thing. You have heard that term. When we are going to take a listing, we ask them, who has a legal right to sell this, to sign the documents? We usually go to the CAD to see whose name's on it. If we see an LLC, then we need the articles of incorporation or such that say who has a legal right for this LLC to sign and sell and buy real estate. And same with the trust. If you see a trust name, you go, okay, I need a document that says who has the authority to sign off on buying or selling real estate. So that's what they mean by power of sale. Who has a legal right to buy and sell property for that entity? So you deal with it every time you take a listing. So yeah, it's just a terminology difference. And also in Henderson County, probate wills is only once a month. And we have to get all the documents. Every county has a different time of month or week that they're going to be, the judge is going to hear of probate. So if you're in Henderson County, it's 3 to 6 months, it's 6 months to a year. So it's very important if you do find out that your clients have a will, depending on what county they're in. But again, we're not attorneys. I just give it some out there. Y'all deal with this, and I close in 30 days. Let's do it.
We're lucky in Smith County where we have hearings every week. You're right, in Henderson County, it's once a month. And if that docket gets full, then you're pushed off to the next month.
In Cherokee,
Yeah, in Cherokee, and if that county's full, you get pushed to the next month.
And if you have anything complicated, they're gonna kick it to county court or district court, and that's gonna take even longer. And when you're at your hearing, you might be sitting next to a criminal, or, a lady going through a divorce, and, your client just lost their spouse. So it's just not a fun situation for anybody.
But assets can also transfer through deeds, and I know we touched on this a little bit earlier, but we've got transfer on death deeds and we have ladybird deeds. And they do pretty much the same thing, but what are the differences?
Yeah, so a transfer on death deed is a creature of statute. So the Texas Estates Code and Property Code reference it, and what it does is it transfers ownership in real estate to a beneficiary upon death. Okay, and the transfer on death deed, to differentiate from other deeds, is the only deed that or instrument that has to be recorded before the person dies. Okay, and if that doesn't happen, then it's no good. Okay, and so it's very simple. It's just like a TOD on a bank account. Okay, does the same thing with real property, but does not convey. Just so you know, for your analysis, it does not convey. Does not deal with anything having to do with a lien. So whether it's a mortgage lien or a mechanics lien or whatever. Whereas a ladybird deed is a creature of common laws created by case law or by courts. And a ladybird deed is the slang term, but the technical term is special warranty deed reserving a life estate. And so mechanically, what it does, if my wife and I own a piece of property, and we implement a ladybird deed, and at the end of the day, we leave it to our 3 children in equal portions, the deed will look like this. Okay, James and Mary Davidson own this. Okay, and in the body of the deed, it'll say grantors, now expressly own this with right of survivorship. Okay, and that right of survivorship is very important because that indicates that when the first of us die, all title vests in the survivor. Okay, and then we're going to convey to the grantees, which are my 3 children, a remainder interest, and that remainder interest doesn't vest until both of us die. Okay, and a ladybird deed can be revocable or irrevocable. Oftentimes they are irrevocable, so that the grantors can sell the property without joinder of the grantees, or cancel it altogether if they change their mind about who they want to benefit. But I have seen scenarios where Brian's taking care of his neighbor Sally, and Sally's advanced in age, and Sally says, Brian, in exchange for you taking care of me, I will leave you my house at the end of the day. So Brian says, okay, I need some assurances, so I'm going to make this irrevocable. Okay, so it's an irrevocable ladybird deed. Sally can't pull the rug out from under Brian if she changes her mind. Okay, they have a contractual agreement, and the deed corresponds with that. And so it can be revocable or irrevocable, whichever way you intend to go in that direction. But the fundamental difference, and why I usually use ladybird deeds as opposed to transfer on death deeds, is one, they do not have to be recorded before the grantor dies. And so in this day and age of big data and counties selling data to everybody who pays for it, anytime you record a deed, it's public record forever. Okay, and so oftentimes I'll just incorporate a ladybird deed into their estate planning binder, and we'll record it when we need to, because the clients don't want their business posted all over the place. And title companies a lot of times, and appraisal districts too, don't know what to do with a ladybird deed. And we're having to call down there all the time saying, hey, you put the name, the tax account in the name of the grantees, and you stripped all of their exemptions. You're not supposed to do that. You didn't read the deed. Go ahead and fix it. And they fix it, but it's time out of our day. And so for those reasons, a lot of times I'll just tuck the deed away into the binder. I'll keep a PDF, and most counties nowadays are e-recording, so we'll just e-record the PDF when we need to. But the fundamental difference as to why I use ladybird deeds more often than transfer on death deeds is the ladybird deeds also give creditor protection on the property from any unsecured creditor. Okay, an unsecured creditor is any creditor that you owe a debt to, and that debt is not secured by collateral being the property. So like your mortgage, your deed of trust, promissory note, that's a secured lien. But unsecured would be credit card debt, medical debt, nursing home. And so the ladybird deed protects the property against unsecured debt of the grantor. And in nursing home situations where we have estate recovery, grandma goes into the nursing home and while she's alive, they let her own her house and still qualify for Medicaid or whatever. But as soon as she dies, you better believe they're going to want to be paid back. And that's called estate recovery. And you probably all dealt with MERP claims and the process of closing. The Lady Bird deeds will protect against that unequivocally, okay? Because that the remainder interest, which is the interest that has been conveyed, is the interest of value, and that has already been conveyed to the grantees. And so any creditor of the grantor's unsecured creditor cannot attach to that property. And so a Lady Bird deed, if you're going to go the will route, and we all oftentimes have clients that say, I don't understand trust. I don't want to learn anything new. I just want everything to be simple and use a will. And I'll always insist on using a Lady Bird deed. In fact, I won't do their plan unless they do the Lady Bird deed also, because I'm not doing my job if I don't. Okay. But the Lady Bird deeds are a very, very powerful tool. And it could be a 10,000 acre ranch worth $100 million, or it can be a $10,000 dollar lot on the corner, over here on the street. Doesn't matter. Okay, it can convey the same interest.
Sorry, to back this up, before I hired them to do my trust, when I closed on my primary house and she was still an adolescent, at closing, at the title company, I actually wrote it myself because I didn't know them, but it was pretty simple. It's in your principles one book, actually, about how to write deeds. But anyway, I did a Lady Bird deed, just a quick piece of paper, had them notarize it, and I did it in front of her, and I gave her 100%. So if I left there after closing and I died, she was already taken care of. I mean, it's that fast, it's that good. And then, of course, soon after that, I called James and said, okay, I really need something real. I'd like to put it all together. Now I have a house and I want her to have it. I have a car and I want her to have it. I have investments and I want her to have it. And so then we went down the trust route. But that's actually what advice I give to my clients at closing. Do you have a trust or do you have a will? Either way, if they say yes or no, I'm still going to give them the phone number. But at the very least, I say, you've got to have a Lady Bird deed. And they go, what is that? And it's wonderful because older people, they grew up thinking they don't have a lot of money, so they don't need a trust or will. And I go, but so you have multiple children, they will fight. No, they'll never fight. Yes, they will fight. So you need to take care of your family now. Do a Lady Bird deed and then give them James's phone number. But a lot of mentality in these taxes is, no, my kids will be fine.
They'll figure it out.
I always tell my clients, you never know someone until you share an inheritance with them.
Yeah.
So you think the kids are gonna be great, but when mom and dad are gone and there's money involved,
Yeah.
it's kind of the true colors show.
It's an amazing tool.
You got a question?
Do you have anybody in your offices that are bilingual Spanish? Fluent?
Not present. But we have utilized interpreter services in the past. Yeah. And so if the client calls and requests for an interpreter in any language, then we'll bear the cost of that and get an interpreter on Zoom.
Where are you guys physically? I see that you have several.
Yeah, so we have seven different offices, one here in Tyler, and so Brian's born and raised Tyler. I married Tyler Wright, and in 2018 we moved here for a period of time. We opened an office here, and my wife at the time took over the family restaurant, which is here, and so we're heavily integrated into Tyler, but Brian is our full-time guy here. And the way that my clientele kind of shaped to be is that I'm not necessarily tied to any particular office, and really neither is Brian. At any given time, I might be in South Texas, I might be in East Texas, I have a client in Miami. I have clients all over the place. But we go to the client wherever they need to be. And if travel is difficult, then we'll go to them. And so we'll make accommodations. And so for our business owner clients, we'll meet them at their place of business and whatever the case may be. But we do have an office here And it's over in Asher Park, near Holly Tree.
That's really close.
Oh, excellent.
How about Terry title and all, not Terry,
True,
True.
the orange.
Yeah,
Yeah.
that's it. All right. I know we've touched on this a little bit before, but the intestate problem, intestate is just a fancy word for you don't have a will. And so there are a lot of problems associated with that. Number one being cost. Number two, there's going to have to be probably some sort of probate involved, but it gets very complicated when you're dealing with blended families and estranged families. And I know we've already kind of touched on that, but if you don't have a will, the state has one for you. You may end up having a spouse that is sharing the house, ownership of the house with other people, with kids of the deceased spouse. And so it can create a situation that just inherently leads to conflict. And so in general, it's always a good idea. If you can't do a trust or don't want to do a trust, like James said, some people just, I don't want it. I don't think I need it. It's too complicated. Even though we try to make it very basic and easy to understand, some people just, that they don't want to do that. And so, but if nothing else, we need to have a will in those deeds, especially when you're dealing with blended families, because it's going to create a situation that can lead to conflict and can be pretty uncomfortable.
Yeah. I mean, for example, I have a client, the wife, married husband in high school got his high school girlfriend pregnant. They were both 16. She had the baby, and she moved, and they never had a relationship. Saw the baby, I think the day it was born, but never saw it again afterwards. So husband in college met his forever wife. They got married, started a family. He worked for Raytheon and built a life together. And in his late 50s, he died of a heart attack. And wife, all of a sudden, called us, and we had a consult with her, and she told us about the estranged daughter. And we had to break the bad news to her that half of everything goes to daughter. And she didn't even know how to get a hold of her. So we had to hire a private investigator to find, she had to pay money to hire a private investigator to find the daughter. We told the daughter, and we were hoping that she'd say, no, I don't want any of that. But she said, nope, this is my payment for all the crap that he put me through. So half of the retirement, half of the house, half of everything, all the plans that they had made during their lifetime were gone. And they had kids of their own as well. And so the kid, all three of the kids took everything, or half of everything. And so it can be absolutely devastating if it is not accounted for and there's not an alternative plan put in place.
I know we're out of time, but
Please,
do we have any questions or?
do y'all have any additional questions for them? If you do need to go to take calls or do your business, please do so. If not, I would like for y'all to continue.
Okay.
This is extremely valuable.
Okay, I just want to make sure that we value y'all's time.
Well, that's what we're all saying.
Okay. The issue with we've got a slide here, the probate problem, and again, we've kind of been talking about this throughout, but of course, with probate comes fees. With probate, you have to notify creditors, so you have to do some sort of notice to creditors in the newspaper. It can be it is really a very public process. And a lot of times you have to follow an inventory of everything that your spouse or your mom and dad own on the day that they passed. And I know this is Tyler, and you don't have nosy neighbors here. but my experience is we've got some nosy neighbors, and if they wanted to, they could go down to the Smith County Courthouse and they could pull up their neighbor's name and they could find out exactly how much they had in their bank account on the day they died. And a lot of people don't want that information out there. And Smith County makes you publish the last 4 digits of the bank account, where the bank account was held. So if it's like Southside Bank and these are the last 4 digits of the account number and here's the balance on the date of death, And you've got to do that for all the probate assets that there are now.
And in the application are the last three of their social and the
Right,
last
that's
three of
their
their
driver's
driver's license.
And so it can be a very public process, and a lot of times people don't want all that information out there just sitting around at the Smith County Courthouse waiting for somebody to go pull it. And so that's another benefit of using a trust is that you're avoiding this probate process. You don't have to publish all of your assets and all the details and all the nitty gritty, of your life. You don't have to notify all the creditors. And so, that's something to think through when you're deciding whether or not you want to do a will or a trust.
Yeah, and that last point on the probate problem is care of minor beneficiaries. So when you have a trust and you have minors that own assets, and in this instance, we'll talk about real estate. Well, the trustee can sell it on behalf of the minors, and it's a relatively easy process. Whereas if you don't have a trust, when you have minors owning it outright, well, you have to get permission from the court. You have to file an application to sell minor assets. And it's a whole process where you have to submit the contract on the property to the court, and the court does a market analysis to make sure that it's market value and who's better suited to know what market is, the judge or the broker or the agent. And so it's a whole process. And then when the property is sold, majority of the time, those proceeds have to be put in the registry of the court. And then mom or dad has to file an application after the fact to gain access to it. And the judge ain't going to do it until they're 18. And so they don't get access to it. Whereas with a trust, it's super simple. And the money is available for the use and benefit of the minor immediately. Yeah.
Incapacity. And again, we've talked about powers of attorney, making sure that you list somebody that can make medical decisions for you if you become incapacitated, somebody that can manage the finances should you become incapacitated. And I always tell my clients, give some backups. A lot of people say, well, I just want to put my spouse. Well, that's fine, but what happens if you and your spouse get out on Broadway and something happens, there's a head on and you both pass away, or you're both incapacitated? Then what? So we need to start thinking steps ahead, as to, I know you've heard this before, but, hope for the best, plan for the worst. And so, we've got to think about kind of, and we want to create documents that you don't have to keep coming to an attorney to change all the time. So if a spouse dies and that's the only person you've listed, then you've got to come back into the attorney and we've got to do new ones. Whereas if you had just listed a couple backups, it wouldn't have been a big issue. And so, those documents are very important. Medical power of attorney, financial power of attorney, directed to physicians, like she was talking about earlier, which is basically a document. A lot of states call it a living will. I still have clients come in and say, I need a will and a living will. But that's just basically a document that states what your preference for end-of-life hospice is. Whether or not you want to be hooked up to machines or not, or if you want to go to hospice. And then, of course, if you don't do anything, you have no powers of attorney in place, and you become incapacitated. You set yourself up for a guardianship issue. And I've done a lot of guardianships in my 25 years, and they're never easy. They're always complicated. They're always time consuming. You always have family members usually fighting. Like I said, especially when there's any kind of wealth involved, you've always got family members that that want to kind of jump in. In Texas, two people cannot serve at the same time as guardian over an adult, but two people at the same time can serve as guardian over a child. And so if you want to plan for guardianship of your children, you can name another couple. But if mom and dad want to appoint all their kids as co-guardians, the law doesn't allow that. So you have to pick one, then the other, which can sometimes be uncomfortable, but it's important to do so that there's no conflicting arguments on the courthouse steps.
I had a guardianship example that y'all have had something similar. This lady, her spouse passed away. She wanted to sell the house. They didn't have will, didn't have trust, no labor deed, no time. And so they wanted guardianship. And so they started asking family members, the nephew, the cousin, and everybody was so scared that he would come back from the grave or like actually become conscious and realize that they sold his house without his permission. And so no one would even agree to guardianship. I mean, I was laughing because it was hilarious to imagine the fear, or maybe respect, but respect they had for this gentleman that was just unconscious but still alive, that no one would do it. So we couldn't do anything. So it becomes a problem. I don't know if that's an East Texas thing or what, but it can be avoided. You know.
Two specialized long-term care trusts, MAP trust and BAP trust, and then just there's the one.
Yeah, I'll touch on this briefly. So folks adults who are disabled, and it could be a mental or physical disability, oftentimes get their insurance and their income through the federal government, through SSI, SSDI, or accelerated Medicare or Medicaid. Okay, so those are all government subsidized benefits, and it's a federal program that the states adopt and kind of tweak it a little bit. But they're means-based qualification standards, meaning that if you make too much or you have too much, well, then you don't qualify. And so oftentimes what we see is, let's say grandma has an adult grandchild who has special needs, and grandma, out of the kindness of her heart, is going to leave, name grandchild as a beneficiary on their $500,000 life insurance policy. And, and special needs person has been, established a pattern through their life of insurance and income through SSI and Medicaid. And they're in their programs and they're doing really good. And then all of a sudden this $500,000 hits, and you think that's a blessing, but now they're disqualified. Okay. And they have to start all over, and they have to burn through that $500,000 in order to requalify. And so if done properly, it's left to a trust or a will that creates a special needs trust. Well, we get to avoid all of that. And so whether it's a special needs or supplemental needs trust, it's the same thing. It's designed to hold those assets for the benefit of the disabled beneficiary and to supplement SSI, supplement Medicaid instead of supplant. So it allows to accomplish grandmother's objective to convey the blessing to the beneficiary, and the beneficiary still get to keep the benefits. And so, it's a very powerful tool that can be life-changing for the parties involved. And then there's Medicaid Asset Protection Trust or Veterans Asset Protection Trust. And really, those are specialized types of trusts that we utilize in scenarios for those who are over the age of 65. And if you can give us 5 years, I can qualify Elon Musk for Medicaid. Okay, we're dealing with a 5-year look-back period, meaning that if you file for Medicaid, Medicaid is going to say, okay, we'll go back 5 years, and if you've divested yourself of any asset and did not receive market value in return, well, we're going to count it as if you owned that. Okay. And so that was elder law planning in the 80s and 90s. Was grandma and grandpa just conveyed everything, gave everything to their kids, and so the government got wise and implemented the look back period, and that halted that. Okay, and so something for you to look at, an issue spot for clients, is the utilization of these trusts. If given 5 years, I can put the home, I can put their $500,000 in investments. I can put all these things in this trust and start that 5-year clock. And once, 5 years has elapsed, then the government no longer counts that as the assets of the client. And so just like supplemental needs trust, we can qualify them at that point, assuming they otherwise are eligible for Medicaid or for different types of Social Security, and we can supplement from their trust to maintain eligibility. And so that they don't have to go on, the basics of semi-private room, $60 minimum monthly maintenance needs allowance and get their haircut and do all of that stuff. We can supplement from the trust pays for it, and it's not considered income or an asset of the client. And for veterans, in addition to Medicaid, there are other veteran benefits through the VA. One specifically that we work with all the time is called aid and attendance, which is basically tax-free money in the client's bank account that they can then use to pay for things like in-home care, or if they're in an assisted living facility, can pay for the medical component of that, or nursing home or memory care. It's an additional benefit available to the wartime veteran and a surviving spouse of a wartime veteran. That can be a very powerful planning tool. But given enough time, again, we can qualify Elon Musk. I dare not say that. I don't know how everybody feels about Elon Musk, but I can qualify any wealthy person, anybody, for Medicaid given enough time. Okay,
And the VA look back is just 3 years.
it's just 3 years. Yeah, exactly.
I have a question. So with those ones, so you say you got it qualified for 5 years, I mean, like, that's a waiting time.
Mhm.
So hypothetically, let's say that somebody is 65 right now, their spouse, are doing long-term care unexpectedly. They're going through that right now, working, they don't qualify. Is it too late for that spouse to give the job? Because right now, it's like, her husband is, Medicare, he's getting the VA stuff, and she don't qualify for nothing, and she's still in 12 years.
It's not too late to
Okay.
do some type of planning. It's probably too late to do the proactive planning. Okay?
Okay,
Meaning getting ahead of it. But there are still things you can do. Okay, that instead of saving 100%, I might be able to save 80%.
okay.
So yeah, it's better than nothing. But yeah, the best thing you can do is get ahead of it, give us enough time. But oftentimes it's unplanned events, right? But even if scenarios where they own a house and that's their only asset, and so one might say, well, they can still own the house and qualify for Medicaid, yes. But what happens if you need to sell the house? You converted it from a non-countable asset to a countable asset. But if it's in the trust and 5 years has elapsed, well, then you can sell the house, you can invest it, you can grow it, you can do whatever you want. So the best thing that you can have in those crisis situations are options. And so by doing proactive planning or some planning at all, you create out of thin air other good options among various bad options. So.
Thank you.
All right, so you've got your plan in place, you got a will, trust, deeds, whatever you've chosen. Now, the important thing is to make sure that it stays current. And so I always suggest to my clients that we revisit the family situation every couple of years. Unless there's something major going on, it might be sooner than that. But every 2 or 3 years, getting back with your estate planning attorney and making sure that nothing in your life has changed that would necessitate a change in one of the documents. But also making sure nothing in the law has changed that would necessitate a change in any of your documents. Law is, of course, evolving. 10 years ago, we weren't really too interested in digital assets. Now we talk about digital assets all the time. That's something that's kind of evolved. When I first started practicing law, we didn't have HIPAA. And so our medical powers of attorney never mentioned HIPAA. Now they do. Now we have a separate HIPAA release just for that. And so it's important to always make sure that your documents stay current. Now we want to make sure that there's current addresses and phone numbers on there so that doctors and hospitals know how to reach your loved ones. But again, just making sure that everything in your life has stayed the same and nothing needs to change. Of course, if there is a change that needs to be made, you have to make those changes. Want to touch on?
Sure. Yeah, and at the end of the day, what we're here to do is to serve clients and add value to their life, right? And you guys are here to do the same thing. And that is all about, differentiating yourself as to why you are the right person to do the job as opposed to other people. And so what we feel like differentiates us is, we are attorneys, and majority of the time I'm not wearing a suit. I'm wearing a golf polo and slacks or whatever. But honestly, we're just regular people, and we don't take ourselves too seriously. And majority of our clients, when they come see us, it's the first time they've met with an attorney. And fortunately, it comes naturally for us. But again, we don't take ourselves too seriously, and we try to be very personable and warm, and make the clients feel comfortable. And through our lifetime planning process, where we're more interested in the relationship rather than the transaction and adding value. And you really can't add value without getting to know the client. And so it's really important to us that we have a no pressure complimentary initial consultation so that we can get to know the client, identify issues, and then propose solutions to those issues where the client can then, make an informed decision with their family as to what the solution is going to be for them. And a part of that process is the quoting of a flat fee. Typically, not all the time, but typically we bill on a flat fee basis, and we will quote the fee, and it's never going to be more than what we quote, and so that they can incorporate that into their decision-making process. And I mentioned unfunded trusts earlier, and how an unfunded trust is really just an expensive paperweight. So the importance of funding, I can't stress enough. And we, as a part of our process, assist with the funding to the degree that we can, drafting deeds, giving letters of instruction on how to retitle bank accounts, or working with their advisors or their realtors or whatever to make sure that everything is titled the way that it should be. Okay. And then we also have what we call a client care program, which very common question as well. After this transaction, what is the nature of our relationship going to be? Well, that's really up to the client. And so if they, to Brian's point, we try to set things up where they're flexible. If circumstances change in the future, we want the document to flex with it. But inevitably, clients change their mind or circumstances change to the point where they need to make changes to the documents or add to it. And if that is the case, then the client can choose, basically an a la carte process moving forward. Say, James, I need this, this, and this. And we quote them a flat fee and we do the work and we move on. Or they can opt into what we call our client care program, where it's an annual fee. The lowest is $800 annually, but they get to make unlimited changes, unlimited additional funding, meet with their children, and we do coaching, whatever the case may be, whatever they need as it ties to the scope of work that we've previously done, it's all covered. And what we have found is that if the client has already paid for it, they're more likely to use it and take ownership of it. And so we like to propose this for clients if they see value in it, opt into it, and then you won't feel the pressure to call me and be frustrated when you get a bill, whatever the case may be, because you've already paid for it. So we have that client care program, and for those clients, it adds value. Establish what the ongoing relationship is going to be like, and with the client care program, it's very clear. Okay, and to kind of bring things to a close and to wrap it up, for you guys, what I would encourage: become a subject matter expert on this stuff. Okay, you don't have to be an attorney, and you will always have to pass it along to an attorney, just like we would have to pass listing a property or whatever along to you guys. Become a subject matter expert so that you can issue spot and you can add value to the client, and you can engage in that symbiotic relationship, whether it's with us or another estate attorney. But find your person and develop that relationship with them, and so that you can add that value to the client, and look at tax implications for real estate transactions. Look at estate planning vehicles and deeds and ladybird deeds, so that when the client presents you with an issue, you've already got the solution, and they see you as the subject matter expert, that you can then make an introduction and add value to the relationship that you have with your attorney, so that, again, when that attorney is in a pinch and they need real estate help immediately, you're the person they go to because they have a relationship with you. And so I will, Brian, it's up to you on whether you want to do this, but I will put my cell phone up here, and Brian can choose to if he wants to. And text me or text Brian if you need anything. Okay. And I'll tell you that majority of the day from 8 to 5, I'm in meetings like this, and I don't check my phone too often. So give us about 48 hours to respond, but we will respond. And help you, whatever you need. We need to jump on a phone call 5 minutes and talk about a situation so that you can then communicate that to the client. But it opens up the line of communication so we can create a back and forth. So I encourage you, plug in our numbers, you know, and like I said, Brian is the primary here. So if you're looking to get in,
Or when your client needs an emergency affidavit of airstrip.
yeah, Yeah.
Which happens quite a bit.
it does. But reach out to us. But in the context of building these professional relationships, of course, this goes without saying, but title companies too. Okay, attorneys and title companies, and there's always an attorney behind a title company, but build a relationship with an estate attorney, build a relationship with a title company, become subject matter experts, and become become valuable to everybody, and then you will see your business, your book of business accelerate.
It was just like Miss Carol was he congratulated her. I don't think y'all were in the room at the time, but she's been working with a client for over 25 years, and they have grown, not just in their assets, but for family too. And that happens to all of us. And you pour in value into your clients. It's not just them that you get to serve. It's their entire family and all of them friends. So it means a lot to people, not just to do the transaction and you get your commission. It's now that you have the largest asset of your life, let's take care of it. Let's create a legacy for your entire family. And what does that look like? And now you're not just a realtor or a sales agent, you're invested in them and their entire life from that day on. And so that's why Carol is known so well throughout the East Texas and Tyler area, because she commits to people, she pours into her clients, and it's a lifetime relationship.
Yeah.
So.
Yeah, become the problem solver. And in the professional world, you know, solutions are a currency. And if you have the solution for everything, then you will be the go-to person.
Any other questions?
I've been texting with my husband. So do the trusts, when you set up a trust, do all of your assets go into it, or are you limited to what assets you can put in?
Good rule of thumb is every asset but retirement assets. Or business assets.
Okay. And then do the trusts file any like tax returns or anything like that?
Certain trusts do, but for your standard revocable trusts, they're considered what are called grantor trusts. So it's a pass-through entity. So you are the taxpayer, so it all goes on your return.
Okay.
So for a grantor trust, which probably makes up 80% of trusts, you don't file a tax return. But for certain complex trusts, you do.
When we said no businesses, but LLCs can actually be in a trust.
Correct.
Which is what we do. Or you'll eventually do. You just have an LLC and then it has to get paid. And
Yep.
so those LLCs can go under the trust as well.
Yeah, and we didn't talk a lot about taxation, but if you can become, and you don't have to be an accountant or an attorney, but if you can become an expert, subject matter expert in taxation, then again, you're going to be invaluable.
Yeah, property taxes.
Property taxes, stepped up cost basis, 1031 exchanges, all of that, primary residence exclusions. There's so much that you can become familiar with. S Corp status. Learn that and learn to issue spot, and you will become invaluable.
Like you both are. So thank you very much for
Of course,
being here.
our pleasure.
I have it videotaped. It was live and videotaped, and so Dalton's gonna put it on our private Facebook page as a video, so y'all can probably download it from there. Okay. All right. Thank you very much. Yay.
And forgive me, we have to take off. We have a